Officer Dave, would you open up the courtroom for us?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Hello?
Hello,
What is your name?
Ananias Spratt.
All right, Mr. Groen is here. All right, let's see. 278. Hold on for a minute.
Yes, sir.
Hello?
Hello.
Yes.
No, counsel, what are you here for?
I am here for Citibank versus Spratt.
Maybe you, all right, I have Mr. Spratt here. We can get started. Your name, your tag on the screen was something besides Citibank, counsel.
I apologize, Your Honor.
If you're not going to do it accurately, don't do it.
Understood.
All right, let's call your file. We are on the record calling file number 22189-569. The file is entitled Citibank versus Ananias Spratt. Date and time for what appears to be our second pretrial, your appearances.
Keith Sparks here on behalf of Citibank, Your Honor, P77485.
And tell us your name, sir.
Ananias Spratt.
All right, where are we on this file, gentlemen? The court opened your written discovery when we were last together on August the 19th. Further ordered that Mr. Spratt was to send to the plaintiff's counsel some things he had sent to the court. Did you receive that information, Mr. Sparks?
We have not received anything further, Your Honor.
Mr. Spratt, did you send that information as I ordered?
Yes, yes, Your Honor, I did.
Who did you send it to?
To the lawyer,
Do you know when you mailed it?
Yes, it's certified mail that I mailed.
When did you send it, sir?
Oh. 2 weeks ago, Your Honor.
It should have been here by now. You sent it to 2618 East Paris in Grand Rapids?
Yes, I did. Certified.
Do you have the card back?
No, Your Honor.
If I gave you my email address, would you be able to just send me a scan and that way we have it?
I can't do it now.
All right, here's what we're going to do, gentlemen. I'm going to give you another pretrial date. The next pretrial date with me will be October 14th at 10 o'clock. Does that work for everyone?
Yes, it does, Your Honor.
Mr.
Yes, Your
Spratt?
Honor.
Now,
Yes, Your Honor.
I want to make something clear. If that information has not been provided to counsel by the time we are together, then I'm going to strike that information. It will not be used at trial, Mr. Spratt. Do you understand what I've said to you?
Yes, Your Honor, I have.
Anything else, gentlemen?
Your Honor, may I just inquire what it is? Is it just his answer?
No, he sent something from CFNA Auto Pass. There were 4 sheets. There was something called an account summary. There was something addressed to him. Looks like auto pass. And again, there was something from somebody on Kelly Road, an invoice. Looks like an automotive invoice. All right, gentlemen, I'll send you out an order today.
Thank you, Your Honor. Thank you,
Thank you
Thank you,
both.
Mr. Spratt.
We're off the record.
Thank you, Your Honor.
Morning.
Good morning.
Mr. Zelen, what brings you here today?
Mendelson Orthopedic versus Jonathan Trent.
I don't have Mr. Trent as of yet.
Your Honor, we had come to a resolution. We had signed a consent judgment. We had submitted it. I don't see it in the register of actions.
Well, let's call your case because you said signed a consent judgment. I probably won't be coming in. Let's 280, 183. We are on the record calling file number 22182-183. Mendelson Orthopedics versus Jonathan Trent. Date and time for what appears to be our third pretrial. Your appearance.
Your Honor, James Zellen appearing on behalf of the plaintiff P69241.
Mr. Zelen, you were telling me you gentlemen have a resolution here.
Yes, we do, Your Honor. We have entered into a consent judgment whereby defendant agreed that he owes the amount paid for in the complaint of $6,962.37, court costs of $205.44, $75 statutory attorney fee, for a total judgment in the amount of $7,242.81. We have agreed to allow the defendant to pay $100 each month starting September 30th, 2022 for 6 months. At that point, we will reach out to be in contact with the defendant to attempt to further have payment arrangements. Mr. Trent has signed that. I have submitted it to the court. It does not appear that your clerks have received it or at least processed it. I would be happy to get it over to the court in another way.
When did you send it in?
It's been at least a week, Your Honor.
All right, what I would do is I would suggest, since you sent it by first class mail,
Yes, Your Honor.
since the post office now says that they take 7 to 10 days to deliver first class mail, I suggest you wait until Monday.
Okay.
Doesn't appear in our register at that point. Why don't you fax it on over to the court? Excuse me, send it over to the court by email at the court's website. There's a trial services portal that you can send everything to.
Okay.
I'll just note that the parties have settled the case and the consent judgment is in the mail.
Thank you, Your Honor.
Thank you, sir. Just be safe.
Thank you.
Bye-bye. Good morning.
Good morning.
Good morning.
All right, I think I have everybody here. This is Meldrika Williams versus Simro Investments. This is 22-242-426. Your appearances, please.
Mildrika Williams.
All right, Ms. Williams, your attorney, Ms. Woodson, is here, so I'm going to mute you, but you'll still be in the meeting.
That's not my turn.
No, Your Honor, I'm the attorney for the defendants. Good morning, Your Honor. Danian Woodson on behalf of Simro Investments, P68870.
Mr. Bernhardt, why are you here?
Mr. Judge, it's Adam Barrett. I'm on a different case, Your Honor.
826? Oh, I'm sorry. You're the 11th. I'm sorry, I got you in the wrong spot. My bad. Sorry about that.
Thank you, sir.
Put you back in the waiting room.
Thank you, sir.
All right. This is a little bit better. Let's try it again.
Okay.
Rika Williams versus Simro Investments. Counsel, your appearance.
Good morning, Your Honor. Danian Woodson on behalf of Simro Investments, P68870.
All right. And Ms. Williams, you are representing yourself this morning.
That's correct.
We are here today on the motion for summary disposition filed on behalf of defendant under MCR 2.116C8. Counsel, your motion.
Yes, Your Honor. Even in the light most favorable to the non-moving party, which in this instance would be the plaintiff, I don't think they have stated a claim upon which relief can be granted. Although they allege property damage and a failure to return a security deposit, they have not indicated the nature of the property damage that was not communicated to the defendants at any time during the lease or after the lease. And one of the primary reasons, aside from the clause in the lease agreement regarding the security deposit, prior to them filing this suit, months after they vacated the property, there was no address to forward any information regarding the security deposit or the reasons for it not being returned to the plaintiff.
All right. Let me hear from plaintiff, Ms. Williams.
Good morning, Your Honor. I did let the landlord know that
Dan, you have to speak up.
I did inform the landlord that I didn't have a moving address, so my place of residence wasn't going to be available. I let her know, and we spoke on the 31st and also before that. So she knew to send my security deposit to the 4251 Glendale.
All right. The court's had an opportunity, and I'm ready to rule on this one. The only matter before the court today is a motion for summary disposition under MCR 2.116C8. There is no motion for under any other provision of 2.116. A motion for summary disposition under MCR 2.116C8 is based on the grounds that the pleadings, because pleadings can be considered in a C8 motion, only says that the pleadings fail to state a cause of action upon which relief can be granted. In this case, the complaint says the defendant has not returned my security deposit. Also, I am seeking court fees and property damage. That's the cause of action. All the other things, Ms. Woodson, you are alleging are factual issues, and they cannot be considered by the court in a C8 motion. The only question is whether or not the complaint states the cause of action. It states a failure to return my security deposit and for property damage. That cause of action is clearly stated. The motion for summary disposition under MCR 2.116C8 is therefore denied. Where are we on this file? Your discovery, as I recall, is closed, correct?
That's correct, Your Honor.
Then what I'm going to do is send out an order today denying the motion under C8. And I'll give you another pretrial date. We'll see you again on the 14th of October, October 14th at 10 o'clock. Does that date and time work for everyone?
Is it possible that this could be in person?
The court rules require us to use remote wherever possible, and everybody's doing remote. What would be this is not a trial. Why would you want to do it that way?
So it could be over and done with. I mean, I'm missing out
The
on.
physical presence doesn't go change what the scheduling of the case, man.
I think and I don't want to speak out of turn for the plaintiff, but I think the plaintiff is requesting a trial date as opposed to a pre-trial date in order to move things along. I don't know if that's what she's doing, but it sounds like it. And if so, then I definitely wouldn't have an objection to that.
You definitely would.
Would not have an objection to the next court date being a trial date as opposed to a
Well,
pre-trial
what I'm
date.
going to do, if you guys are ready for trial, I'm going to send you the case evaluation.
Okay,
And the way that works is that we will send you the case evaluation. And what will happen is that the parties will prepare, in essence, a case evaluation summary. You appear in front of a panel of 3 people, 1 lawyer who represents plaintiffs, 1 lawyer who represents defendants, and 1 neutral. And a presentation is made by each side. That panel then endeavors to come up with a unanimous recommendation to settle the case, not try the case, settle the case. If there's a unanimous unanimous evaluation, you reject that evaluation at your peril. And that is because if there's unanimous evaluation, the side that rejects the evaluation finds itself subject to paying attorney fees. The American rule in general is that each side pays its own attorney fees. If there has been a case evaluation and an award that was unanimous, that was rejected by one side, accepted by the other, then whichever side does not improve its position by 10% at the time of trial will have to pay attorney fees for the other side. So I'm going to send out 2 orders, and we'll send out an order referring the case to case evaluation. I'm going to give you an October 14th trial date. Not trial date, pre-trial date, just to make sure we don't lose track of the file. And hopefully by that time, you'll be able to tell me what your case evaluation date is. And then we can work on from there. Anything else we can accomplish today?
No, that would be.
what time on the 14th, Your Honor?
10 o'clock like today.
Could we have 10:30 or 11? I have a 9:30 probable cause. It's also on Zoom that day, Your Honor.
Or 11 then. Does that work for you, ma'am?
11 is fine.
Okay. October 14th at 11 o'clock. Case will be sent to case evaluation. Thank you for coming in. I'll send out 2 orders. There'll be an order sending the case evaluation, and there'll be an order denying the motion for summary disposition for the reasons stated on the record. It is the obligation of the plaintiff, Ms. Williams, let me make this clear, to contact the Wayne County case evaluation people and make the arrangements for that evaluation. Thank you all for coming in. We are off the record.
Thank you.
Thank you, Your Honor. Have a great one.
Be safe.
Thank you. You too.
We are on the record calling file number 22242826, Travis Foster versus Huntington Bankshares Incorporated. By a notice dated August 29th, 2022. This matter is set for hearing today at 10 o'clock on the plaintiff's motion to set aside the dismissal. It's now after 10:30. Could I have your appearance?
Your Honor, Adam Barrett, P58607, on behalf of the defendant, the Huntington National Bank.
This matter is before the court on the plaintiff's motion to set aside the dismissal. The case was previously dismissed when plaintiff failed to appear for a pretrial on, this looks like August 10th, 2022. Plaintiff has failed to appear for plaintiff's motion to set aside dismissal. Motion to set aside the dismissal will be denied. We'll send you out an order today, sir.
Thank you, Your Honor. Take care. Have a nice weekend.
Be safe out there.
Final symphony is always going to get something. Classic untalented line, London Symphony Orchestra, 63. Michelle Ann Folletta, who's the music director. WIC Joe. Stay warm for the weekend. Something's pushing inside.
Morning, Council.
Morning, Your Honor.
See if I can get this other guy to come up. Get started. Okay.
Good morning, Your Honor.
Morning. Let's call your case, gentlemen. This is 22-187-684. Select Specialist LLC versus the ASU Group Suburban Mobility Authority. Date and time for what appears to be our third pretrial after this case came over to me by way of a change of venue. Appearances, please.
Good morning, Your Honor. Mohammed Musa on behalf of Plaintiff Select.
You remember the State Bar of Michigan, Mr. Musa?
P number 84297.
Counsel?
Good morning, Your Honor. Joseph Giacalone, P85482, appearing on behalf of defendants Smart and the ASU Group.
All right, where are we on this file, gentlemen?
So previously, Your Honor, when I spoke to Mr. Muhammad Mackey from AK Law, we were in the process of trying to settle out this case and figure where we were at. We had just gotten discovery from back from the plaintiff in that case as a couple weeks ago. We didn't have it at the time of the last pretrial. We're also in the process of defending 7 other provider suits as well as the underlying claimant's main suit. So we're trying to organize those cases and potentially whether it would go to a facilitation or the cases would settle on their own. We're still in discovery process on a bunch of them.
Counsel?
That is correct, Your Honor. I do see that we exchanged discovery and we're hoping to get this one wrapped up.
All right, let me ask you this. In my case, is there any outstanding discovery?
No, Your Honor.
No, Your Honor.
Okay, and the amount of your claim, Mr. Musa?
I believe it's $5,129.80.
Okay, so there's no question you're gonna stay with me. You're not gonna exceed my jurisdiction. All right, let's do this. Let's give you guys another date. And if you haven't gotten it resolved by that date, then I might want to close your discovery and move in another direction. But let's see if things get resolved. Things tend to get resolved toward the end of the year. Does October 14th at 11 o'clock, does that work for both of you?
That works, Your Honor. Thank you.
That works, Your Honor.
Okay, let's get working on, see if we can't kill this one, gentlemen. In the meantime, be safe out there. We'll talk to you October 14th, 11 o'clock. Anything else we can do today?
No, Your Honor.
Nothing, Your Honor.
All right, be safe. Thanks for coming in. Well,
Thank you.
Have a enjoy your weekend.
you do the same.